All right, senior advocate and former Union Minister Kapil Sibal is addressing a press conference. Let's cross live.
Ill-advised and hasty. Why is it unprecedented? Because never before in the history of India an impeachment motion moved by members of parliament has been dismissed at the preliminary stage. Therefore, it is unprecedented. It is illegal because the chairman has passed an order which is required to be passed after a full-fledged inquiry. Let me now explain to you what the procedure in law is. If 50 members of the Rajya Sabha move a motion for the impeachment of a judge, that motion has to be dealt with by the chairman, not in his judicial or quasi-judicial capacity. He has to see whether the motion is in order or not. Have 50 members signed it or not signed it? Are the signatures genuine, not genuine? Is the motion in order? Is the motion in order consistent with Article 124 of the Constitution? And if it is absolutely frivolous, means it has nothing to do with misbehavior of the judge, he can take a call. He doesn't act in any quasi-judicial capacity at that stage. Once the motion is admitted, then under the Judicial Judges Inquiry Act of 1968, the motion is sent to a panel of three. One sitting Chief Justice of a High Court, a judge of a High Court, and a legal luminary. Judge of a Supreme Court and a legal luminary. Then a full hearing in the sense that evidence is led, documents are submitted, witnesses are called, and the inquiry committee either comes to the conclusion that the charges are proved or not proved. If the charges are proved, then the motion is in the form of an address to the President of India for removal of a judge for proved misbehavior. Why? Because the Judges Inquiry Committee, after taking evidence, finds that the charges are proved. So proved misbehavior comes after the inquiry. It cannot come before the inquiry, right? So that is why it is illegal, because the chairman of the Rajya Sabha has said that we've not been able to prove misbehavior. He says the prefix proves, the prefix proved places an obligation of actually proving the misbehavior before the parliamentary procedure starts. How can something be proved before it is proved? It can only be proved after an inquiry. It can't be proved before an inquiry. So it is illegal. 3, it is ill-advised. Why is it ill-advised? Because the procedure requires him to consult the Chief Justice of India before he admits the motion. Now, he can't consult the Chief Justice of India, obviously. So he should have consulted members of the collegium. He has chosen not to do that. Some of the allegations relate to what is happening in court. He has not consulted any judge about what is happening in court. One allegation is that he sends matters to most sensitive matters to particular judges. He should have consulted why judges feel disturbed about that. So without consulting the judges in respect of matters that happened in court, it was ill-advised of him to reject it. And last of all, hasty. What was the tearing hurry? If a motion is moved by the signatures, valid signatures of 64 members, which he admits, and there is a whole petition moved with documentation, excerpts of conversations and other things, obviously it takes time for any normal person, even I as an experienced lawyer, I must say that it takes me time to understand an issue, because I'm not superhuman. Before we argue a case, it takes days of consultation. You consult the law, you consult briefs, you read the facts, you digest the facts, right? It takes some time. But obviously there was some tearing hurry. And I don't think momentous matters like this should be disposed of in this fashion. Remember, it is our privilege to move the motion. You can't boot the privilege in this fashion. Now, one of the charges, now he also says, and very interestingly, he says he need not weigh the pros and cons to find a prima facie case. He quotes a judgment of the Supreme Court and says that in that case it was the Speaker, but in this case the Chairman need not weigh the pros and cons for a prima facie case. But apart from dealing with the prima facie case, he's given a finding. If he can't weigh the pros or cons for a prima facie case, how can he give a finding? Then he says, and very interestingly, he starts off in the order by saying that I will accept all the charges to be correct. He says that the only test that is to be applied, and I will read it, I have to apply a test that if every statement stated in the petition is believed to be true, would it still amount to a case of proved misbehavior? So if you accept every statement to be true, then you have to admit the petition. Then you can't question it. Now he says, but in our statement we have said that it appears that there has been an antedating of an order. So he said because the motion has used the word appears, it is a conjecture. But if he starts with the presumption I must accept everything to be true, then he must also accept that it appears to have been antedated to be true. So he says that. Then we said that the judge may be involved in a conspiracy with respect to what happened in the medical college case. He says, but the conspiracy is not proved. But as you know, no conspiracies can be proved by like that, by direct evidence. All conspiracies normally are proved by circumstantial evidence. That circumstantial evidence can only come about when you lead evidence. It can't come about in any other way. So he says, because conspiracy doesn't stand proved, I reject it. Because he says, the charge is that he may have been involved in a conspiracy of paying illegal gratification. But if you accept that to be true, then you must admit the motion. So he has applied the test of proved misbehavior, which happens after an inquiry, to a stage before the inquiry has started, which of course is unknown to law. And he says that all this is not verifiable. No, it can only be verified if there is an inquiry. How do you verify something without an inquiry? So it seems to us that this government is very keen that this must not be allowed to be inquired into. Maybe they have information that the CBI has information. Maybe by scuttling the inquiry, they don't want a lot of information to come on record. And this is our fear. If they are aware of that information and they have that information, then it puts the judicial system to jeopardy. And then it seems to me that there is a presumption which seems to be prevalent as we read the order, that 64 members of parliament don't seem to have applied their mind when we move the motion. I think that this unprecedented order only shatters the confidence of the people. It destroys the legitimate processes of the law. It seeks to hide. It seeks to ensure that no inquiry takes place. It jeopardizes the judicial system. We will certainly move a petition in the Supreme Court to challenge this order. And we are confident that when we move that petition, the Chief Justice has nothing to do with it. When we move it, so that it is heard, and the serious issues which are constitutional in nature and which will determine whether we will bring transparency to the process or not will be decided by the court. Thank you very much. हिंदी में अब इस संक्षेप में बोल देता हूं क्योंकि बात इसमें क्योंकि लीगल बातें हैं ना, तो खैर मैं संक्षेप में बोल देता हूं कि आज 23 अप्रैल को जो मोशन हमने 20 अप्रैल को चेयरमैन राज्यसभा को देकर मूव की थी, उसको चेयरमैन राज्यसभा ने खारिज कर दिया है।
Senior advocate Kapil Sibal saying that the vice president's rejection impeachment motion is illegal and he did not follow due procedure. The war of words between the opposition and the government continues on the impeachment motion. This is our top focus on India Today. Stay with us for more.